I'm Alonzo Martinez, Associate General Counsel at HireRight, and this is the Compliance Playbook, our second quarter 2025 compliance review. While I'm a lawyer, today's webinar is not intended as legal or compliance advice. My intentions are to give you information that you'll take as talking points to raise with your teams and your legal counsel. That said, pick up your phone and snap that QR code to follow me on LinkedIn, where I post compliance-related content weekly. Before we begin, a few housekeeping notes. To receive HRCI or SHRM credit, you must attend the full live session. Credit details will be emailed next week along with a link to a webinar recording. We aren't distributing the slide deck. If you experience any audio or video issues, try refreshing your browser by pressing F5 or use the Q&A icon to reach out. Carrie and Doreen are producing today's session and will be monitoring the feed for any technical issues. After the webinar, please take a moment to complete our brief survey. Your feedback helps shape future sessions, so we'd love to hear what worked and what topics you'd like to see next. One more thing, we're continuing our live and after hours Q&A today. My friend and colleague, Nicole Campion, will be answering your questions in real time, and we'll host a short Q&A session after the main presentation to recap and cover anything that we missed. So please stick around if you can. Let's talk about the second quarter of 2025 and why we've called this year's webinar series the Compliance Playbook. This quarter, employers faced a series of regulatory curveballs. California finalized sweeping rules on automated hiring tools. Colorado implemented new biometric privacy mandates, and federal immigration enforcement threw a spotlight on I-9 compliance, catching many employers off guard. But Q2 wasn't just about keeping up with new laws. It was about having a game plan. The pace and the complexity of these changes meant that reactive compliance, it's just not enough. You need to anticipate, adapt, and respond strategically, just like a well-coached team on the field. And that's what today's session is about, helping you build and refine your compliance playbook. I'm going to walk you through the major developments, connect the dots, and offer practical guidance so your organization can stay informed, agile, and ready for whatever comes next. So here is today's game plan. I'm going to take you through key developments from Q2, state laws, local ordinances, federal activity, and litigation that's shaping how employers screen and hire. We're going to move quickly, but my goal is to give you clear, actionable takeaways for your compliance strategy. You're going to find supporting resources by clicking the resources icon on your screen. Again, look at that resources icon, including a companion article. That's the Compliance Playbook, Key Employment Law Changes for Background screening in Q2 2025. So again, take a look at that companion article. If you're taking notes, that article is a great supplement and you're getting an early look. It'll be live on Forbes this Friday. I'm always working to make these sessions valuable. So if there's a topic you'd like me to dig into next quarter, let me know in the survey after this session. And remember, if you have any questions as you're going through the materials today, use that Q&A icon liberally. Nicole Campion is doing the heavy lifting today. She's going to answer these live during the webinar, and we're going to continue the conversation in our extended Q&A after the presentation. We're going to kick things off today, as always, with a broad discussion on criminal history reform. Let's start with a high-level overview of clean slate laws across the United States. These laws give individuals a second chance by sealing or expunging criminal records once they've stayed crime-free for a period of time. The goal is to remove barriers to employment and the stigma associated with criminal history. For employers, here is the key point. Once a record is sealed or expunged, it becomes inaccessible through public court indexes. That means it's not going to appear in a background check. So take a look at that map. Every state except Wisconsin offers some form of record relief. States in red offer broad expungement of misdemeanors and felonies. Orange states have more limited eligibility. And the stars indicate states with automatic relief, meaning that the process happens behind the scenes without requiring the individual to file a petition. In other states, the burden's on that person to take legal action to help clear their record. Wisconsin, as you'll see, is the lone outlier. While judicial pardons are available, the state does not offer a direct pathway to sealing or expunging records. For those who want to go deeper into clean slate laws, we've included links to our two-part guide on automatic record relief in the webinar resources, so check it out. Nicole wrote that document, those two documents, and they're really, really helpful. They cover convictions and non-convictions as it applies to clean slate laws. So let's turn to Hawaii, our first state update, where lawmakers are expanding access to automatic expungement for low-level drug offenses. In April, the state enacted Act 5 of 2025, building on last year's expungement pilot under Act 62. That pilot, the 2024 pilot, focused on individuals arrested for minor marijuana possession in counties with 200,000 to 500,000 residents. So counties like Maui and Kauai, but not Oahu, Honolulu. And Act 5 keeps those limits, but it expands eligibility to include Schedule 5 drug possession arrests. To qualify, the arrest must have occurred before January 11th, 2020. It must involve a single charge that resulted in a non-conviction, and expungement must not otherwise be barred by law. The process remains fully automatic, so there's no petition, no fee. The Attorney General's office initiates and issues the order for sealing on its own. For employers, this means that low-level drug arrests may start disappearing from reports, particularly in counties like Maui. These records are being cleared at the agency level and may no longer appear in public record searches. This is part of a growing national trend, states using automated expungement to erase stale, low-risk records, helping, again, to remove those barriers for candidates without requiring individual action. Interesting, though, that Hawaii has chosen to take a phased approach in smaller counties first. Now let's talk a little bit about clean slate laws rolling out in 2025. You've probably seen this information before. A quick recap: Minnesota now allows automatic expungement of petty crimes and nonviolent misdemeanors after 5 years, certain felonies after 8 years. Violent, domestic abuse, and sexual offenses are excluded. While the law took effect on January 1st, implementation just began in mid-May. So you're going to see some of those older records still appear as that system catches up to expungement. Colorado has been automatically sealing civil infractions after 4 years, misdemeanors and petty offenses after 7, and soon certain felonies after 10 years. Eligibility lists are issued quarterly, so expect records to drop off in waves. Virginia passed clean slate in 2021, but sealing isn't going to start until next year, July 2026, unless the courts can upgrade their sealing technology earlier. This is a common theme you're going to see. Automatic sealing will apply to misdemeanors and dismissals dating back to 1986. Petition-based sealing is available for lower felony offenses and deferred dismissals, and even ancillary matters like probation violations, those could be eligible for sealing and expungement as well. Moving on to Washington, D.C., they have also joined the trend. Its Second Chance Act took effect this year, and starting in January of 2026, you're going to see decriminalized or unconstitutional offenses be automatically expunged. Dismissed charges can get sealed right away. Non-convictions will be sealed after 10 years, and for convictions, 5 years for misdemeanors, 8 years for felonies, unless they're excluded specifically from sealing. Again, things like domestic violence, certain sexual offenses. Bottom line, employers should expect to see more sealed records and reduced visibility of low-level offenses across these jurisdictions. Let's shift to ban-the-box laws. The jurisdictions shown on this chart prohibit private employers from asking about criminal history during the early stages of hiring, usually before the initial application or the interview. States marked in red, these laws apply broadly to all types of workers, including contractors and gig workers. So if you pay somebody to do a job, the laws in red apply to you. In that aqua column, you're going to find jurisdictions that require pre-adverse notices specifying the criminal conduct at issue. In the blue column, employers must go a step further and conduct a formal individualized assessment explaining how the offense relates to the job. Cities like Los Angeles and New York City in that wine column require even more, such as city-specific documentation as part of the adverse action process. Then you have places like Wisconsin, Madison, Wisconsin, Louisiana, and Atlanta, Georgia, which don't prohibit early inquiries. They don't actually ban the box, but they still require individualized assessments before rejecting a candidate based on criminal history. These are fair chance laws. So The bottom line is that ban the box compliance and fair chance compliance, it is a deeply local thing. You're going to need to tailor your applications, your workflows, and your documentation to meet these varied requirements across the jurisdictions. Let's take a deeper dive into Washington State's fair chance law, where House Bill 1747 makes sweeping changes to the state's Fair Chance Act. It's going to take effect in two phases. First, July 1st, 2026, next July, for employers with 15 or more employees, and then January 1st, 2027, for those with fewer than 15. This is now one of the most stringent fair chance laws in the country. Here's what's changing. First, timing. Currently, employers can consider criminal history after confirming the candidate is qualified for the job. Under HB 1747, you have to wait until after making a conditional job offer. That's the difference. If you're screening earlier, you have to revise your hiring process. The second big change, decision making. You can't take adverse action based on arrest records or juvenile convictions. For adult convictions, you're going to need a documented job-related reason supported by an individualized assessment that considers the severity of the offense, time since the conviction, and any evidence of rehabilitation. If after considering that information, you plan to revoke a job offer or affect somebody's employment, you have to provide a written explanation outlining the conviction, your rationale, and any mitigating circumstances, and must include at least 2 business days before taking that action. Remember that while Washington requires 2 business days, that waiting period, the FTC has actually opined that you're supposed to wait at least 5 business days. That's a reasonable standard. So there's a little bit of a difference between guidance and what Washington's actually requiring. Importantly, this law applies to current employees as well. So you can't discipline or terminate someone over an arrest or juvenile record unless it's clearly job related and well supported. Here is the bottom line. Start preparing now. Review your screening process, move background checks to post offer, train your teams, and ensure your decisions are thoroughly documented. For HireRight customers, we've already updated Compliance Workbench. So if you use it, you can begin complying now if you choose to do so. Let's turn to Wisconsin, where a recent state Supreme Court decision significantly broadened what qualifies as an arrest record under the Wisconsin Fair Employment Act, or the WFEA. So the Supreme Court in Wisconsin ruled that arrest records include not only criminal arrests, but also non-criminal citations like municipal or civil violations. That is a big shift. Wisconsin employers now have to treat any law enforcement citation as protected under the Wisconsin Fair Employment Act. So here is how we got here. Here's what happened. 2 school employees were accused of pocketing money from recycled scrap metal. The school district investigated but didn't assign blame to those employees. Later, the police issued municipal theft citations. So again, municipal theft citations, not criminal charges, and the district fired both employees the next day, citing dishonesty. The citations, though, were later dismissed. The employees filed complaints and the court agreed with them. Even though the citations weren't criminal, they were still issued by law enforcement, so they counted as protected arrests. The court said that employers can't take adverse action based on a citation, whether it's criminal or not, unless a narrow exception applies. So what does this mean for you in practical application? It means you can't fire, discipline, or refuse to hire someone just because they received a citation. If the timing suggests that the citation motivated your decision, you could be in violation of the WFEA. What about internal investigations? Wisconsin law allows employers to act on misconduct based on an independent internal investigation. This is known as the Onalaska defense. But that defense only works if your decision is clearly based on your own findings and not triggered by a law enforcement citation. In this case, the employer had already finished its investigation. The only new development was the citation, which the court saw as the real reason for the termination. One justice noted that if the employer had acted before the citations were issued, the outcome could have been different. So what are your key takeaways? Well, treat all law enforcement citations as protected under the WFEA. If you suspect misconduct, Act early before citations are issued and document your investigation. When in doubt, placing an employee on leave while you investigate may be safer than just terminating outright. At the end of the day, this decision expands legal risk and it reinforces the need for defensible, well documented processes when employment decisions intersect with what law enforcement is doing. There's an interesting juxtaposition there. And I understand that you're probably have some questions about that. So keep getting those questions in, and my friend Nicole will continue to answer those for you. Let's head over to Minneapolis, where a major update to the city's civil rights ordinance introduces one of the most progressive local employment protections we've seen this year. Starting August 1st, 2025, justice impacted status, that becomes a protected class. Employers hiring in Minneapolis now have to rethink how they use criminal history in employment decisions. So, what does that mean? What does justice impacted status mean? Justice impacted status covers a wide range of experiences, including arrest, charge conviction, incarceration, probation, or parole, regardless of whether the matter was resolved or is still pending. So, in effect, a significant portion of the city's population now qualifies for this protection. This is very interesting. To be clear, background checks are still allowed, but adverse action based solely on criminal history is prohibited unless the offense is reasonably related to the job. And to determine that, employers have to apply a six-factor individualized assessment. You have to consider whether there was a conviction, how much time has passed, the nature and gravity of the offense, the individual's age at the time, any evidence of rehabilitation, and risks to real property or people. So, what does this mean? Again, you can't reject someone based on an arrest alone. And if you consider pending charges or dismissed cases, you have to still apply that six-part test. So how does this work in practice? Well, think about it in two steps. The first step is timing. Under Minnesota's statewide ban the box law, remember that Minnesota has that ban the box law in effect. You can't ask about criminal history until after a first interview, or if there's no interview, until after a conditional offer. Once you lawfully receive the record, Minneapolis's ordinance controls how you use that record, how you consider that record. And that's when that six-factor test applies. So to put this simply, state law tells you when you can ask about criminal history, city law tells you how to use what you've learned. This basically mirrors the EEOC's 2012 guidance on arrest and conviction records. If you haven't read it, read it. I always say that. That guidance, the EEOC's guidance, isn't binding, but Minneapolis is one of the first jurisdictions to codify that. So the takeaway for you, you can't just say we don't hire people with felonies. That blanket policy won't hold up under the new ordinance. Employers have to evaluate each case individually and document how the offense relates to the job. Because justice impacted status is now a protected class like race or gender, legal risk is significantly higher. Discrimination claims could arise if employers fail to update their policies and their practices. So, in short, justice impacted status is now a civil right in Minneapolis. If you're hiring in Minneapolis, your screening policies, your job descriptions, and manager training all need to reflect that. Let's wrap up this section of the compliance playbook with some actionable takeaways from this quarter's wave of criminal history reforms. So we've seen strong momentum behind clean slate legislation this year. Minnesota, Colorado, Virginia, and Washington, D.C. are each expanding or launching record sealing frameworks in 2025. And Hawaii extended its automatic expungement pilot last month, broadening eligibility for low-level drug offenses. That is a clear signal to you employers. It tells us that jurisdictions are leaning into automation to deliver second chances more efficiently. For employers, the key is timing. These laws often promise automatic suppression, but what we've seen is that the implementation rarely happens overnight. So you're going to see a difference between when records are supposed to be expunged and when they're actually expunged. Expungement systems are really complicated, so courts and record custodians need time to catch up. As a result, again, you're going to see those outdated records show up in one background check, but maybe not in the next. You're going to want to factor that variability into your adjudication strategy. In Washington state, the revised Fair Chance Act creates new compliance risks by requiring individualized assessments and detailed documentation before withdrawing a conditional offer. That is a fundamental shift, and it means hiring managers need to understand what a compliant decision looks like and how to explain that decision. Wisconsin also raised the bar. The state's Supreme Court expanded arrest record protections under the Wisconsin Fair Employment Act to include non-criminal citations. In other words, even a municipal ticket might now trigger legal exposure if you base a hiring or firing decision on it. If you operate in Wisconsin, this ruling should prompt an immediate review of how you respond to law enforcement involvement in any sort of matter. And finally, Minneapolis just made history by adding justice impacted status to its list of protected classes. That means individuals with a criminal record now receive similar protections as candidates based on race, gender, or disability. If you're hiring in Minneapolis, you need to conduct a 6-factor individualized assessment before making any decisions tied to a criminal record and document how that history relates to the job. So, what is the bottom line here? I would say the bottom line is that this is no longer about checking boxes. It's about building smarter, more adaptable screening programs that keep pace with this very fast-paced legal reform. If you are a HireRight customer, here are a few tools that can help. Compliance Workbench can guide you through ban-the-box obligations and timing requirements. Variable unlimited search depth options give you visibility into reportable criminal history beyond that typical 7-year window. And our managed adjudication and adverse action services help you build consistency and compliance into your hiring decisions. The legal landscape around criminal history is shifting fast, but with the right playbook, you can stay ahead while promoting fairer, more inclusive hiring practices. And don't forget, we have included links to relevant resources in the webinar dashboard, that resources section, including articles, guidelines, guidance, templates, all of those things, all found in the webinar resources section. If you have any questions about anything we've covered in this section, use that Q&A icon to reach out. And if you need help updating your processes, your accounts, or if you want any information about any of our tools or services, let us know in the post-webinar survey. We are here to support you. Really great engagement, by the way. Please keep getting those questions in. Nicole is here to help you out. So let's shift gears and talk about pay equity and transparency. These are what I consider 2 pillars of modern employment law. You've seen a lot of this. Pay equity laws, they aim to close wage gaps by preventing discriminatory pay practices. A core feature of these laws is a ban on asking about a candidate's prior compensation, because the thought here is that past pay shouldn't dictate future opportunities. Pay transparency, on the other hand, is all about visibility. These laws require employers to disclose salary ranges in job postings or upon request. The goal? To give candidates and employees a clearer picture of compensation expectations up front and to level that playing field. So let's dig in and look at this map. It shows where salary history bans are currently affected, 29 jurisdictions in total. Here's what this means for your hiring processes. You can't ask candidates about their previous salary, and you can't use past compensation to set current pay. But there is a safe zone in all of this. You can ask about salary expectations, questions like, what are you hoping to earn in this role? That is perfectly legal, and those questions can give you insight without crossing any compliance lines. This next map highlights pay transparency laws. These are jurisdictions that require some form of pay transparency in hiring. Most of these laws require that the posted salary range reflects what the employer reasonably expects to pay for the position. The idea is to set honest, data-backed expectations so that candidates aren't left guessing and employers aren't negotiating in the dark. Let's take a closer look at new pay transparency laws effective in 2025. Illinois and Minnesota began enforcing their laws on January 1st, requiring employers to disclose salary ranges and, in some cases, benefits in job postings. The details vary, especially in terms of employer size thresholds, but this direction towards pay transparency is clear. Massachusetts adds another layer. Employers with over 100 workers must now report pay and demographic data, with rules taking effect at the end of the month, July 31st. New Jersey and Vermont round out this quarter. Both states introduce new disclosure rules later this year. Vermont's law, it is especially robust. It requires that job postings disclose tip wages, commission structures, and starting pay for hourly roles. So you can see all of these laws differ just slightly in their requirements. Let's talk about Cleveland, which just passed one of the most expansive local pay equity ordinances in the country. Cleveland's ordinance bans employers from asking about or using a candidate's salary history, and critically, it requires that job postings include good faith pay ranges. It applies to employers with 15 or more employees, including those hiring for part time, temporary, or commission based positions. Cleveland is now the fourth major Ohio city to restrict salary history inquiries and require pay range disclosures. If you hire in Ohio, you'll need a consistent approach to ensure compliance across Cleveland, Cincinnati, Columbus, and Toledo. Now let's head over to Washington State, where compliance just got more manageable, at least a little bit. Washington's Equal Pay and Opportunities Act, it already requires that employers include a salary range and benefits that are disclosed in every single job posting, and a ban on using or requesting salary history in hiring. But as enforcement of the Wisconsin Equal Pay and Opportunities Act ramped up, employers faced an onslaught of class action lawsuits, often for these really minor technical missteps. That pressure prompted legislative action. So SB 5408, effective in 2025, makes three important changes. First, a 5-day cure period. If someone notifies you that a job posting is missing required info, you now have up to 5 days to fix that without any penalty. Second, it offers more flexibility. If you're offering a fixed salary, you don't need to pretend it's a range, it's a fixed salary. And you're not liable for third-party job boards posting outdated listings as long as you take action once notified that those are incorrect. Third, it's clarified penalties for us. Instead of a flat $5,000 per applicant damage, penalties now range from $100 to $5,000 per violation based on the size of your company and whether the mistake was intentional or not. So the bottom line here is that the rules haven't changed, but enforcement has been fine-tuned. So for now, this is a rare opportunity to review and correct your postings without the fear of automatic penalties. This is a rare win for employers, so please take advantage of it if you hire in Washington State. Let's wrap up this section of the Compliance Playbook and with a few key takeaways. So first, audit your job postings. Make sure that they comply with new or updated pay transparency laws in Illinois, Minnesota, Massachusetts, New Jersey, Vermont, and Cleveland. Second, apply Washington's Equal Pay and Opportunities Act carefully. It now explicitly covers remote roles. So if a job could be performed from Washington, you are on the hook, but you are given a brief reprieve from any non-compliance. Third, standardize pay bands and job classifications. It's really the best way to stay compliant across a patchwork of jurisdictions. And finally, train your hiring teams. Pay transparency laws don't just impact your job ads, they shape the entire conversation about compensation. So make sure your recruiters know how to talk about pay lawfully, clearly, and consistently with your candidates. Pay transparency, it continues to gain traction. We see this every single quarter, not just as a compliance requirement, but as a reflection of shifting candidate expectations for employers. That means staying agile, keeping your policies aligned with the law, and ensuring your pay practices reflect the values your organization wants to project. This is a space where regulatory change and cultural changes are happening side by side. I think it's one that is really worth watching closely. Keep getting your questions in as they relate to pay equity and transparency laws or anything that we've talked about today. Let's pivot now to cannabis reform. You're going to hear me use the words cannabis, marijuana, and THC interchangeably. Again, cannabis, marijuana, THC, they're going to all be used interchangeably. They all refer to the same substance. I use the same approach in my writing, so please don't let my use of that terminology throw you off. Here is a snapshot of recreational cannabis laws across the United States. As of now, 23 states plus the District of Columbia have legalized recreational use, also called adult use. But what matters for employers is how these laws affect your testing policies. In red states, you can still test for THC and act on a positive result. Those aqua states, you need to be a little more cautious. These laws restrict adverse action based solely on a positive cannabis test. In blue states like California and Washington, you can't rely on traditional urine tests to detect non psychoactive THC metabolites for pre employment purposes. You're going to have to either drop THC from your panel or switch to oral fluid testing. Again, California and Washington, you can't rely on traditional urine tests to detect non-psychoactive THC metabolites for pre-employment purposes. You're going to have to drop those from your panels or switch to oral fluid testing. I always like to remind employers about that. There's still a lot of confusion there. Purple states like New York, Minnesota, pre-employment testing for marijuana is generally prohibited unless a legal exception applies. So let's take a look at our medical marijuana map and what it means for workplace accommodation. So this map breaks down a few different things. First off, red states, they do not require accommodation. So there's no obligation to adjust job duties or policies for medical cannabis use. Aqua states, on the other hand, do. They impose anti-discrimination protections, meaning you may need to accommodate medical cannabis use unless it causes you undue hardship. Blue states are silent. There is no clear rule either way, which makes it a bit of a gray area. And those purple jurisdictions highlight Philadelphia and Pittsburgh, where medical cannabis users enjoy specific protections, including bans on pre-employment marijuana testing. So regardless of location, federally regulated roles and safety-sensitive positions are generally exempt. Your policies should reflect those carve-outs, those exceptions. Remember to always update your policies. Let's head over to Minnesota, where a new law, Senate File 2370, adds another layer to cannabis testing rules. Let's take a look back. So remember back in 2023, Minnesota legalized recreational marijuana and severely limited when employers can test for THC. Most employers stop testing unless the role falls under a narrow exception, like safety sensitive positions, DOT covered roles, or jobs linked to federal contracts requiring drug free policies. SF 2370 builds on that. Now, if you're eligible to test and you plan to discipline or terminate a registered medical cannabis patient who tests positive, you have to provide written notice at least 14 days in advance. So again, you have to do this as part of your adverse action process. That notice has to include the specific federal law or regulation at issue and the federal benefit, contract, or license you believe is at risk. So these general concerns about workplace safety, you can't just fall back on that. That's not going to be enough. You need a documented legal basis for your disqualification. There is an exception. If delaying action would violate federal law or jeopardize a contract, you can act immediately, but you still need clear documentation to support it. So what is the practical impact to you in Minnesota? Most employers aren't going to be affected. You should have already stopped testing for THC. But those in, let's see, transportation and defense and healthcare, government contracting, you now face an extra compliance step. You're going to have to update your drug testing and adverse action policies, train staff on that 14-day notice process, and work with your legal counsel to confirm that any federal-based actions are defensible should you choose to take them. So this law doesn't eliminate your right to act. It just requires transparency before you do so. That sort of procedural pause, I'm curious if it could become a model for other states. Let me know what you think when you're completing that survey or as part of the Q&A. Let's keep it moving and talk about Kentucky. In Kentucky, the state's new medical cannabis program took effect earlier this year. For employers, the impact is minimal. The law doesn't require accommodation, and you can still enforce drug-free workplace policies. It also doesn't create a right to sue for wrongful termination based on patient status or guarantee unemployment benefits for policy violations. So, in short, nothing really changes for most employers, but it's worth revisiting your policy language to ensure consistency. Again, updating your policies are key. So let's close this section of the compliance playbook by bringing it all together. If you haven't revisited your medical or your marijuana policies in general, this needs to happen. Like now is the time to take action. You want to start with the basics. So first, prohibit on-premises and on-duty marijuana use. This should be clearly stated regardless of legalization status in your state. All jurisdictions allow you the right to prohibit on-premises and on-duty marijuana use. Understand the difference between medical and recreational use. States like Minnesota and cities like Pittsburgh now protect registered medical cannabis users with specific rules. Third, you want to train your managers. In states like New Jersey, Rhode Island, Montana, and Washington, D.C., you can't act on a positive marijuana test alone. You need these observable signs of impairment. So supervisors should know how to spot impairment and document those signs. And adjust your testing panels. New York, Minnesota, Philadelphia, they've all banned pre-employment THC testing. In California and Washington, and now in Minnesota, oral fluid testing could become a compliant alternative. So be mindful of these local laws. Pittsburgh prohibits both pre-employment and random marijuana testing for certified medical marijuana patients. And if you operate in Minnesota, follow that 14-day notice rule before disciplining a medical marijuana user, including affecting their employment if they are a job candidate. Your notice has to identify the federal law or contract at risk. So what is the takeaway today? Cannabis legalization is evolving rapidly. Compliance isn't just about whether marijuana is legal or not. It's really more about how your policy responds to it. So update those policies. Being proactive with policy updates and training, it could really help you avoid costly mistakes later. Let us know if you have any questions about your drug testing panels or our drug testing products as you complete the survey, and get your questions in using that Q&A icon. Let's shift gears now and talk about legislation and litigation that doesn't neatly fall into our earlier categories. I like to think of this section as our potpourri of compliance. It's diverse, it's sometimes surprising, but it is still very important to talk about. Let's kick things off with New Mexico, which recently became the third state to legalize the medical use of psilocybin, also known as magic mushrooms. Unlike Oregon or Colorado, which legalized psilocybin by ballot measure, New Mexico took a legislative route, enacting the Medical Psilocybin Act on April 7th of 2025. The program's not going to be fully operational until the end of 2027, but for employers, it's a good opportunity for you to start thinking ahead. Most importantly, New Mexico's law does not require you to accommodate psilocybin use at work. You can continue enforcing drug-free policies and prohibiting on-duty impairment. One thing that I will note is regarding testing. Yes, you could technically test for psilocybin, but it's expensive. It has a very short detection window and it doesn't indicate impairment. So for most employers, behavior-based protocols are a better approach. I've talked to Dr. Simo about this, and he agrees impairment is really the best approach for psilocybin. So the takeaway here, frame your drug testing and accommodation policies around impairment, not presence. Prepare for future requests these are accommodation requests related to medical psychedelics, and you're going to want to monitor other states. We're going to see this space continue to evolve quickly. Now for one of my favorite parts of the compliance playbook, audience participation time. I'm calling this segment a dose of discrimination, and it's based on real life legal dispute. You're going to hear the facts in the complaint, and then you're going to decide, was it legal or not? So let's just jump in. Here's what happened. A veteran living with PTSD applied for an activities coordinator role at a senior living facility in Florida. This wasn't a safety sensitive or regulated position. During her interview, she was upfront. She disclosed that she takes legally prescribed medications that could trigger a positive drug test. She volunteered this information in good faith, hoping to avoid any issues later on. The hiring manager was supportive. They told her not to worry and advised her to share her prescriptions with the drug testing lab. She followed the instructions, she took the test, she disclosed her medications, and then she waited and waited. After several follow-up emails and voicemails, someone at HR finally answered the job offer. What did they do? They rescinded it. There was no explanation, no conversation, no effort to engage in any sort of interactive process. So she filed a complaint. She alleged that the employer failed to accommodate her disability, improperly relied on a potentially biased drug test, and revoked the offer based on disability related bias, specifically her PTSD and her prescribed medication. So now it is your turn. Did the employer comply with the law or cross the line? You be the judge. What do you think? Get your answers into this poll question. Did the employer violate the ADA by pulling the offer after learning about her prescriptions without investigating or following up? Let's see how you vote. Waiting for around half of you to get your results in. So get those answers in, please. Really good audience engagement again today. So thank you for getting your questions and answers in. As you get your answers into the poll question, remember we're going to do an after hours Q&A. So we are at a good spot. So let's see how you decided. The vast majority feel like the employer did violate the law by not accommodating her prescription medication use under the ADA. And you are right. The jury said yes, and they were emphatic. They found that the employer violated the ADA and awarded over $405,000, most of it in punitive damages. Here's what made the case so compelling. The applicant disclosed her prescriptions up front. The employer told her to proceed, but when that positive drug test came back, they made no effort to confirm it was lawful. So this wasn't really about the drug test. It was about the employer's failure to engage. Remember that the ADA requires employers to follow up when a disability or a medication might explain a particular drug test result. So if somebody flags a potential issue, you can't ignore it. You have to investigate. So you're going to want to train your hiring teams to recognize those moments and respond appropriately. Compliance isn't just legal, it also has to be procedural and it has to be human. That was this quarter's You Be the Judge. I hope you enjoyed it as much as I did. Let's keep it moving as we're in our last 20 minutes of today's presentation. Let's go to Spokane, Washington, where the city passed a first of its kind ban the address ordinance. Effective May 25th, 2025, this law prohibits employers from asking about a job applicant's address or housing status until after a quote unquote provisional offer. Why? Because many applicants, especially those experiencing homelessness, face discrimination based solely on where they live or they don't live. This ordinance in some ways mirrors ban the box laws, and it aims to ensure candidates are judged on their qualifications, not on their zip codes. From a compliance perspective, you're going to want to audit your applications and interview scripts. If they include questions like, where do you live? Even if that's like an informal question, it is time to revise your policies and train your hiring managers and recruiters. Now over to Oregon. House Bill 3187 expands the state's age discrimination protections. Starting later this year, employers can't ask about age, date of birth, graduation dates until after an initial interview or conditional offer, unless a legal exception applies. Other states, California, Colorado, also have similar laws. You're going to need to make sure that your ATS or screening tools aren't collecting age-related data too early. This law also removes age limits for apprenticeships, ensuring older workers aren't excluded from training opportunities. So the bottom line here is check your forms, your applications, systems, and habits to avoid unintentionally screwing out older applicants or asking about age early in the hiring process. So let's wrap this section with a few notes for our compliance playbook. Psychedelic drug laws are changing, but workplace safety rules aren't. You can still prohibit impairment on the job. ADA obligations kick in when lawful medication may cause a positive test. You must give candidates a chance to explain their lawful medication use. Spokane's ban the address law means no housing-related questions until after a conditional job offer. And Oregon's new law means no DOB or graduation date requests before an interview. These kind of potpourri developments, they may feel very niche, but they illustrate how compliance is becoming more detailed, more localized, and ultimately more litigious. Even small compliance missteps can lead to big consequences. So this is why it is incredibly important to stay informed. Let's move on now to AI, privacy and emerging technology, an area that's rapidly reshaping how we think about compliance across the employment lifecycle. This map shows all currently active and soon to be effective comprehensive state data privacy laws. Recently passed laws are marked with a star, and those becoming effective in 2025 are shown in aqua. So far this year, we haven't seen any new privacy laws enacted, but momentum remains strong in states that have active bills like Massachusetts, Michigan, North Carolina, Pennsylvania, and Wisconsin. That's what we're monitoring today. One key reminder, all of these states carve out exceptions for data regulated by the Fair Credit Reporting Act or the FCRA. That means that background checks conducted by HireRight and similar providers are not subject to these laws. They remain governed by the FCRA's federal framework and not a state data privacy law. Still, these laws matter. Many HR systems collect personal data outside the background check process. That includes applicant tracking systems, onboarding portals, and workplace surveillance tools. So it's really important that you evaluate what data you collect, how it's used, and whether your vendors are compliant, and whether it's subject to a particular state's law. California, I'm looking at you. Here is a map tracking state and local AI laws with a special focus on those that affect employment decisions. We're seeing more jurisdictions adopt rules targeting automated decision making, including AI driven resume screeners, interview analytic tools, and productivity monitors. A few examples, we have New York City's local law 144, which requires annual bias audits for AI hiring tools and advance notice to applicants. We have Illinois, their AI Video Interview Act mandates notice and consent when using AI in video interviews. California and Colorado have enacted broader laws that apply to AI systems across sectors, including employment. Texas recently adopted TREGA, which I'm going to cover in just a moment. The bottom line is that there is a clear trend. Whether it's transparency, consent, or accountability, AI regulation is accelerating. Employers need to get ahead of these changes, especially if you're using third-party tools to help make hiring decisions. And if you use homegrown tools, make sure you know how those homegrown tools work. Let's zoom in on Texas, where lawmakers passed the Texas Responsible Artificial Intelligence Governance Act, or TREGA. This new law takes effect on January 1st, 2026. And while it's sweeping in scope, its impact on private employers, it's relatively narrow for now. Unlike Colorado's AI Act, TREGA focuses primarily on public entities and healthcare providers. It doesn't impose audit, impact assessment, or disclosure requirements on private sector employers using AI in hiring or promotion decisions. But that doesn't mean it's irrelevant. TREGA still prohibits intentional discrimination using AI, and it specifically limits legal liability to cases where employers act with intent, meaning that unintentional bias or disparate impact by itself does not create a violation under the Act. That's important. The law also contains two important compliance signals for us. First, cities and counties in Texas cannot pass stricter local AI laws. That means you're not going to face a patchwork of conflicting requirements within the state of Texas. Second, enforcement is limited to the Attorney General to district attorneys. Companies have a 60-day cure period before formal action begins. So for employers using AI in Texas, this is a good opportunity to review how your systems work, especially if they're used to make certain decisions that could be considered consequential, like hiring, termination, or access to benefits. While TREGA isn't especially burdensome, it underscores the need for AI systems that are fair, explainable, and legally defensible. Next up is California, where the Civil Rights Department has finalized regulations applying the state's anti-discrimination laws to automated decision systems, or ADS. These rules take effect on October 1st, 2025, and while they don't impose new audit or disclosures, they clarify how the Fair Employment and Housing Act, that's California's law, applies to AI tools that use AI or algorithms to make employment decisions. Here are a few key points for you. An ADS, an automated decision system, is broadly defined. It can include anything from resume filters to ranking tools to automated performance scoring. Second, employers may be liable for discrimination even if the tool was developed by a third-party vendor. Liability can also extend to agents, meaning staffing firms or tech providers acting on your behalf are also liable. Regulations emphasize that certain selection criteria, like unexplained employment gaps, that can act as proxies for bias against caregivers, older workers, or people with disabilities. So the bottom line is that California expects employers to know their tech and vet their tech. Even though there's no mandatory bias audit or disclosure requirements, the message is clear. Using a homegrown or third-party AI tool There is no shield from legal risk. You need to understand how your tools work. Let's go into Colorado, where a major update to the Colorado Privacy Act now introduced strict new rules for the use of biometric data in the workplace. The Biometric Data Privacy Amendment becomes effective July 1st, 2025. For the first time, the law extends to HR data, meaning that if you collect fingerprints, facial scans, or voice prints from employees or applicants in Colorado, these rules now apply to you. So you're going to need to understand that there's no private right of action here. Enforcement is handled by the state attorney general, but it's not the type of law that you want to overlook. If you use biometric tools for timekeeping, access control, you have to make sure that you understand the state's standards, especially in multi-state operations. To wrap up this section of our compliance playbook, AI, privacy, and technology compliance is moving fast, and it's affecting every stage of the employment lifecycle. States are regulating how employers use automated tools to make hiring and promotion decisions. Privacy laws are expanding to cover HR data, especially when it comes to biometrics and workplace surveillance. And while some laws, like Texas's TREGA, are relatively light touch, others, like California's and Colorado's, they impose strict requirements and obligations on you as employers. If your organization uses AI tools, biometric systems, or workplace analytics, now is the time to audit your use cases, to review your vendor contracts for compliance support, ensure HR and legal teams are part of any technology procurement process. And again, make sure you really understand your tech. These are not just IT issues, they're compliance issues. The legal landscape is only getting more complex from here. Keeping up with it is very, very important. It's, to me, a very interesting area of the law. I hope you agree with me. Let's shift gears and open the compliance playbook on one more item, this time for I-9 and E-Verify. We've got two very quick but important updates that could impact your hiring workflows. First up, the new Form I-9. USCIS released an updated version dated January 20th, 2025, with an expiration of May 31st, 2027. The changes are subtle but significant. The fourth checkbox in Section 1 now says an alien authorized to work. That's updated to reflect the exact language used in immigration statutes. Two List B documents have updated descriptions, and the privacy notice and instructions were clarified to be more legally precise to the statute. Here's the important part. You can still use the August 1st, 2023 version, but many onboarding systems mistakenly display an expiration date of July 31st, 2026. That's not right. And if you rely on that system-generated date, you could run into issues down the line. So flag this now and make sure your teams are aligned before the system retires that older form. Over in E-Verify, changes went live on April 3rd to sync with the new I-9 language, that alien authorized to work language. That means if an older I-9 says non-citizen authorized to work, the E-Verify system will now display an alien authorized to work. This terminology update applies across E-Verify, E-Verify Plus, and all web services. Even if you're using an older form language, the platform will relabel the status automatically when submitting a case. No technical changes were made to the interface control agreement, but developers and system integrators should still take note and update labels where needed. These are minor updates on their face, but they reflect a broader push towards statutory consistency. And in today's heightened enforcement environment, details like these matter. Let's move to an urgent and complex update catching many employers off guard. In fact, a client brought this to my attention. In June, USCIS began issuing status change reports in E-Verify for individuals paroled under the CHNV program. That's the humanitarian entry process for Cubans, Haitians, Nicaraguans, and Venezuelans. The humanitarian entry program, it's been terminated, and many of these individuals are now losing their work authorization. As of just yesterday, last night, in fact, July 15th, USCIS issued a press release noting that the status change report now indicates revoked document number. There's a field for that now. So that should allow E-Verify employers to check whether an employee's C11 EAD has been revoked. If it has, the employee has to be re-verified using Form I-9 Supplement B. But here is the challenge. Only E-Verify employers receive these reports. So not all employers use E-Verify, right? Many employers don't know unless an employee self-discloses or fails re-verification. Really odd disconnect there. Also, not all C11 EADs are CHNB related. Some are valid for asylum or other protections. So what do you do? First, don't assume that all C11 EADs are invalid. Second, you're going to want to compare EAD card numbers to the report if they're available. And finally, and most importantly, consult your immigration counsel before taking any action regarding employment status. This is a real life compliance issue. If you haven't reviewed your policies for handling sudden revocations of work authorization, now is absolutely the time to do so. This, in my opinion, is a real mess. So what should your compliance playbook include when it comes to I-9 and E-Verify? First, make sure your systems reflect the new Form I-9 and the updated terminology around work authorization. That means training your onboarding teams, updating electronic platforms, and watching for inconsistencies in form expiration dates. Second, verify that your E-Verify users understand that the April 3rd language change. It's small, but if left unaddressed, it can introduce some confusion during onboarding or your audits. And finally, prepare for the fallout from the CHNV program revocations. Whether or not you're enrolled in E-Verify, you could have impacted workers on your payroll. And while we're just starting to get federal guidance, the burden ultimately falls on employers to navigate re-verification lawfully and sensitively. So the takeaway here, even seemingly small immigration changes can have big operational implications. Staying proactive by reviewing I-9 records, watching E-Verify alerts, and coordinating with legal counsel will help minimize disruption while keeping your hiring processes compliant. Sign up for those USCIS alerts. They're really helpful. Before we close for today, here is a quick reminder. We offer a wide range of resources to help you dive deeper into today's topics. If something piqued your interest, whether it was clean slate laws, AI regulations, or E-Verify developments, check out the HireRight Resources Library, our blog, and our Forbes compliance articles. And if you haven't already, scan that QR code on the screen to connect with me on LinkedIn. I post a short video every week breaking down the latest compliance developments and what they mean for employers like you. So that brings us to the end of the prepared proportion of today's webinar. As mentioned earlier, we're going to transition now into our brief after hours Q&A session. If you joined us for SHRM or HRCI credit, you've officially met that 1 hour requirement, so you're welcome to drop off whenever you're ready. Before you go, please take a moment to complete the feedback survey. It's truly my report card, and your input helps shape future webinars. You're going to receive a follow-up email next week with your credit certificate and a link to the recording so you can revisit any sections or share them with your team. For those staying on, let's dive into your questions. We're going to keep the Q&A tight, no more than 15 minutes. With that, let's bring Nicole in. Nicole, thank you so much for the heavy lifting today. Incredible engagement out there. About 1,000 of you on today, so thank you for joining us. Any themes, trends you saw in the Q&A today, Nicole?
Not too many, but one or two. One that seems to be a fairly common theme for us, and I know we talk about it a whole lot. The big question of what law actually applies. If we have a candidate in one state and we're in another state, or the candidate works remotely, which ban-the-box law, which pay equity law do we have to follow? And it's the traditional lawyerly answer of it depends. It really does depend. It's about what the law says. Each one defines their scope a little bit differently. So you really do have to just look to each individual law to really understand it. And we do have resources for a lot of these that help with that, I think. So you may want to look to the resource library for that. Alonzo, anything to add on that point?
I think you hit it. And I think, a lot of employers tend to adopt a somewhat consistent policy, in particular, the more conservative approach, right? So if you're thinking about trying to comply with the law and you're not sure, it's probably better to just comply with it than not comply with it. So certainly the conservative approach always wins.
Absolutely. The other theme I think we got a couple of different questions on were specific to laws that restrict when you can ask about criminal history. We've had at least one or two people ask, if we don't run a criminal background check, does that mean we can ask some other way about criminal history? For example, in states that require you to wait until a conditional offer, can we ask about it pre-conditional offer if it's not a background check, but it's something else? And I think a lot of states would say no. For the most part, the laws do outline pretty specifically what they consider to be inquiring into criminal history. I think that generally they probably define it to cover a lot more than just a criminal background check, but Alonzo, you're a little closer to those. Do you want to talk on that just a little bit?
I agree with your assessment 100%. I think the key issue here is this concept of inquiry. And while inquiry may not be defined in a particular ordinance, law, statute, whatever it may be, I think generally the legislative intent is that inquiry would also include asking about criminal history. So again, I think the safest approach here is to not ask about criminal history until at minimum after a conditional offer of employment. And of course, in a city like New York City, a conditional offer of employment is completely different, right? So you have to first assess that an individual is qualified before then making that conditional offer and then inquiring into their criminal history. So it's even more complex on a jurisdiction by jurisdiction basis.
Absolutely. All right. Let's do a couple really good questions that came in that I haven't had a chance to answer yet. We have one about pay equity and pay transparency laws. The question is, in states where you're required to disclose benefits in job postings, what do you do if you don't provide any benefits? It's a really good question.
Great question. Yeah, really interesting question. And, I would say in all of the jurisdictions that I've reviewed that have active pay equity, pay transparency laws, they generally say a general description of benefits, right? So I think that the safest thing is you can go one of two ways, right? You can simply not include a benefits description, but then should you be challenged, you have to identify to that regulator that you don't include benefits as part of the option. The safer option would certainly be to say no benefits included within this position. I get that that's not the most candidate-friendly thing, and it could be a deterrent to candidates. But if you're looking to take a risk-averse approach, I would say that that is probably the most risk-averse approach you could take. Great question, though.
Yeah, absolutely. We have a couple different flavors of this question, but I think we can kind of put them all together in one set of questions about cannabis laws and exceptions, specifically if there are exceptions for safety sensitive roles, DOT roles, federal contracts, anything like that. So do you want to talk about those exceptions for a little bit?
Sure. So let's talk about, I think, the broadest exceptions, which would be for federally regulated positions. So every single law that has legalized medical or recreational cannabis, adult use cannabis, has included an exception for federally regulated positions as well as for federally bonded positions or positions subject to federal funding or contracts. So that federal scope is always going to be an exception. So your DOT regulated positions will always be exempt from these laws. Now, safety sensitive positions are a completely different thing. Some laws specifically identify the types of safety sensitive positions that are subject to that exception. Other laws say that it is at an employer's discretion as to determine that a particular role is safety sensitive, and if so, you can justify it as being safety sensitive. Other laws say that you have to approach that particular law's regulator to identify whether or not the role is safety sensitive. So you actually have to approach the regulator and say, hey, I'm hiring this individual to operate a forklift in my warehouse. Is that forklift operator a safety sensitive role? And you have to then obtain approval. Other laws, and I'm thinking about Philadelphia here, if I'm not mistaken, they do not have a carve out at all for safety sensitive positions. So you cannot take a safety sensitive approach in that jurisdiction at all. So the bottom line, federal roles, federally regulated roles, always exempt. Safety sensitive roles, not always exempt.
All right. Up next, Spokane's new ordinance banning the address. We've got a set of questions here. I, again, think we can combine into one big question. For businesses who include the address on the job application, do they need to remove it entirely, or could they make it a non-required question? What would Spokane, Washington say about that?
So there's no guidance for us right now, but if you read the ordinance, a plain reading of the ordinance would tell you that you cannot include the address question at all on the initial application. You can't make any inquiries. Again, we're using that word, right? That operative word, inquiries into address, until after a conditional offer of employment has been made. So if you're currently using an application, whether it's online, paper form, or any form that includes an address field as part of that initial employment application, or otherwise collecting an address before a conditional job offer, you need to change your processes. And here's one thing that I think can trip up somebody and could potentially be a compliance issue. It's like a common thing to ask, what part of town do you live in? I'm curious to say to cure. I'm curious if that could even be a prohibited compliance inquiry in the city of Spokane. Like a little thing like that could be a trip up. And I would say just train your folks to eliminate any of those address-based questions, and certainly update your documents to remove any address inquiries prior to a conditional offer of employment.
All right, I think the last big set of questions we have are around Oregon's age inquiry law. So the primary questions are if we need to ask these questions for some sort of requirement, because the state requires they be 18 for a role, or because we have some other obligation that requires us to hire someone who's a certain age. Are they then allowed to ask for age questions or age information, or do they have to wait until some point later in the process?
So Oregon does have exceptions to its age-related inquiry law. You can find those exceptions in the statute itself, and I believe I have covered that in the Compliance Playbook article that we included in today's webinar. If I have not, we'll include that in the follow-up. But yes, you'll want to review those exceptions. Those exceptions do generally apply where required by law or regulation to make an age-related inquiry. But you can find a more narrow answer within the statute itself.
Right. And then the last set of questions is fairly specific to current HireRight customers, how to find certain things in the system, or how Compliance Workbench functions. So for those, I think the recommendation would be to reach out to your account manager or your customer service representative, and they should be able to help you find whatever you're looking for.
Absolutely. And remember to take a look at our resources library for HireRight customers. We also have Compliance Central made available to you. So you'll find that in Screening Manager, in Compliance Central, we post current events and articles, both from ourselves as well as our law firm partners. You'll also find our sample forms in there. And just a quick plug regarding sample forms. Remember that for HireRight customers, we did just go ahead and issue in June. Did means June. We issued a new pre-adverse and adverse action packet with sample templates for your reference. So again, if you want to begin complying with Washington's revised Fair Chance Ordinance, which does have new modified pre-adverse and adverse action requirements, as well as individualized assessment requirements, we've included sample templates for your reference there. We've also included sample templates for use within Kansas City, as well as Wisconsin and Madison, Wisconsin, which recently amended their ordinances as well. So take a look at those sample packets. Let us know if you need any help if you're a HireRight customer by reaching out to customer service or your account manager. Anything else for today, Nicole?
I don't think so. I think that's it for today.
Amazing. Well, thank you again to our audience. Really incredible engagement out there. That officially wraps today's session. Just a quick reminder, the full webinar will be available soon in the HireRight Resources Library, and your credit details will be emailed to you next week. So thanks again for spending a part of your day with us. I hope you found today's discussion valuable, actionable, and relevant to your role. Take a moment to complete that exit survey. Your feedback directly shapes how we improve and grow these sessions. Again, it's my report card. We're going to be back in October with our Q3 compliance webinar. And in the meantime, I hope you stay connected through Forbes, the HireRight blog, and LinkedIn. On behalf of Nicole, myself, and the entire team at HireRight, thanks again. We appreciate you.